Hey everyone, glad to have you back. Today we're diving into a case where a self-proclaimed sovereign citizen watches his entire fantasy collapse as a determined judge and a razor-sharp prosecutor team up to tear his arguments apart, leaving absolutely nothing standing.
All right, the court will call the case of the state of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people. And standby counsel, Assistant Public Defender Jay Bellinger for Mr. Eric Martin, who appears via Zoom. Mr. Martin, can you please unmute and state your name for the record?
I'm a living man, capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. One of the people, sovereign, not a legal fiction corporate entity defendant with the name similar to mine. Here by special appearance, to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me, or are you appointing it for you? Or is it
So
just standby?
I made my decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's how I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Yeah, that's it. Well, that's how I was going to make the motion to dismiss him if you're trying to appoint him for me, which, as I already said before, I will not be taking no attorneys. I'm one of the people. I'm not a defendant who's, so as I said before. So I'm not going to be a
Nobody's forcing you to rely on the attorney, but the judge is simply fulfilling her responsibility to safeguard your constitutional rights by appointing standby counsel. Because at some point you might finally realize just how far beyond your abilities this situation really is.
I assume I'm a defendant, and which would then fraudulently give the presumption I'm under the jurisdiction of the court, which I'm not. As I said before,
You got 5 minutes to make your arguments, and you can spend them however you want to.
All right, yeah. Like I said before, I'm a living man. So, as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent, and it's also under. There's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some questions, though, for the prosecutor.
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
Well, I object to that. That violates my right to a due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not, There's no standing, shouldn't move forward, but... So what's your ruling on that?
Your motion is denied as to jurisdiction and standing. Now, do you have any additional motions?
I object to that because you didn't allow me to answer the questions to see whether you had a legit basis to make that ruling.
Your objection is noted. Next.
You say you're going to be questioning me about the some demands that made to dismiss the case anyway, right?
I'm sorry, what?
You said you're going to be addressing some demands for dismissal I sent to you already. You're going to
First of all, a demand is not a proper format before a court and could be dismissed outright. However, I'm going to allow you to make your motions here. If you want to make an argument, you can do that, sir.
Okay, I object to that. That's not true. As I mentioned before, demands, when someone has the right to something, that's what the terminology demand is made, and that's the only reason why I make it. Motions, even though I know that's all you see in the court rules or whatever, traditional, but that's for a request, and persons or humans are not supposed to be requesting constitutional rights. Me exercising my unalienable right, human rights and constitutional rights. I'm supposed to be making demands. That's how I've been, and that's backed up by law. And that's how I've been taught. And so that's what, So it's all right and proper. Motions are requests, you know. And the defendant makes motions also, since I'm
So you're about the end of your 5 minutes.
Well, I objected 5 minutes being any time limit also.
I don't care about what you're objecting to. You can make it on the record. It is noted. Now, if you have something that you want me to address, you should do that before your time is up.
Putting a limit on my First Amendment right, that's unconstitutional.
Sir, please, if you want to have something to say other than the circular talk that you're doing, you should probably do that at this time.
I didn't finish. That's why I didn't mean to, none circular. I didn't finish the first time. All right, well, that's it. As to that,
is the court ready for the people's response run?
I don't know if he's done with his motion.
Oh, I'm sorry.
I'm trying to make.
Well, the police. I wanted to question the police officer who wrote the ticket. I have a relevant question to him as to self-incrimination. Move to dismiss the case based on that because he.
I thought you all claimed the police held zero authority over you. If that were true, then an officer would have the same level of power as a random person like me, meaning he couldn't demand your ID under any threat any more than I could.
But my memory was it's a little, I don't really remember exactly what was said. That's why I kind of need to question him to refresh the memory. But I do remember in general, though, he kind of, I'm required to give my ID if I remember right, and I might have been arrested if I didn't give my ID, which was under threat and duress. And even if he didn't say that, which I don't remember, which I guess I need to have his body cam and all that. I want to be able to review that now, and also for the trial, if this goes to trial, I want the video present as part of my due process right for the evidence, which is my due process right, like I'm saying. And because, like I said, it violates my self-incrimination right, that I'm being made to give my supposed name, government name anyways, which ain't really my name, but a government name has been given. Violates self-incrimination. And then it's used against me to prosecute. So it violates self-incrimination. Yeah. Move to dismiss based on that too. Then, like I said, if you need more evidence as to, like I said, his questions, then he needs to answer my question. I was about to send out interrogatories to him. I'm about to do it here soon. If you find that's necessary, unless you find it ain't necessary, I'm gonna send it out soon. So, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you, for violating my constitutional rights during this case. So you may want to consider recusing yourself. I know you probably didn't get a receipt yet because I just sent it out like 2 days ago. So the court will be getting it, if they didn't get it already, begin this week. And yeah, so I want that out.
As to your motion to recuse, that is denied.
Based on.
The truth is, you're completely out of your depth here. That's exactly why. And you haven't offered a single valid point that would require the judge to step aside. Just like with a public defender, you can ask for someone new, but that doesn't guarantee you'll actually get one.
That's my reason. That's why I didn't mention that, but I thought you might kind of already figure that. But conflict of interest due to the lawsuit being filed, that's the grounds of my demand for dismissal.
Okay.
And I would like to, Ms. Duffy, as the prosecutor, I'd like to notify you, of the crimes being committed against me by the police officer, in this case, writing the tickets, and I request you prosecute them for this, because I'm the crime victim here in reality. Because I was traveling by right, which the U.S. Supreme Court said we have, as long as you're not carrying passengers property for profit, you're not technically driving a motor vehicle. Therefore, all these charges are baseless. There's no case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle, and then with these charges. Okay, so they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 USC section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, oh, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay, and therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration.
Well, the problem for you is that you're not standing in some open public space. You're in a courtroom. And even though this is happening over Zoom, the exact same expectations, rules, and procedures hold as if you were physically present. Now let's listen to the prosecutor, who's about to dismantle every belief he's been clinging to.
Right, under that federal statute and the U.S. Supreme Court case law that I cited already in the court that they sent back. But one of the main cases here is Packard versus Banton, U.S. Supreme Court case law. Okay, this is a little more specific than just saying people have a right to travel. It mentions there specifically, and I'm going to mention right here, Volume 44, Supreme Court Reporter, page 259. The streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislator deems proper. So as they're saying right there, so we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pull me over, stop and wrote a ticket, none of that. So I'm the crime victim. I request you prosecute him for that. And it's also a federal crime, which I'm going to be contacting the FBI about. I already tried once. I got to call him back.
Why would you even call the FBI? Especially when it's obvious they didn't take you seriously enough to call you back the first time.
Anything else, Mr. Martin?
Well, I'm going to see if you got my, if you're going to, I would like to just reiterate my, the demands for dismissal already made, or if you want to call them motions, but like I said, I like using the word demand because I want to, I don't agree to no unlawful presumptions that, because I understand the legalese a little bit where you say one word and it means something else and it's presumed. And that's why I demand also that there be no legalese used in no stages of this case, because that's one of the fraudulent things going on in the court system. I'm going to be filing a class action to stop this on a grand scale, but I know it's happening. That's why, like, for example, I use the word demand to use the word motion, and it can be presumed you're a defendant. Because defendants make motions, see? So that's why there should be no legalese used here. It's fraudulent, it's wrong, it's immoral, it's pathetic. Whoever made this stuff, because it's putting it's a blanket on a lot of people that don't know no better in the system. Something else. Now, when this proceeding started, I noticed on the screen it said no recordings are allowed. Okay, now I object to that, in that violates my due process right to preserve evidence, me or anyone else, and I'm not just speaking for me, I speak for everyone else. All the people have a right to record in any public court. This is all public. U.S. Supreme Court already said this. People have the First Amendment right to record in public anywhere. And it's also a due process right to preserve evidence. Because if my rights are violated during these proceedings or any other, along with anyone else's, we have the right to record that and have that evidence to bring criminal or civil charges. So that's why that's not supposed to be popping up on it.
Yikes. Looks like somebody didn't bother to properly read the case law they're trying to lean on.